Hello and welcome to the inaugural podcast of the Legal Innovation Society. My name is Beatrice, Vice President and author of this episode, and I am joined with our President.
Hello, my name is Ali. I'm the president of the QMLIS Legal Innovation Society, and today's topic is: can an AI system be considered the creators of material in UK law? This is very interesting, as recently IP law and AI law has been very contradicting in some cases. Well, we will discuss it here, and Beatrice is going to be going through that today. Thank you.
Thank you very much, Ali. So the topic I will be focused on today is centered around intellectual property, in particular patent and copyright law, and how AI generative material has affected these sectors. Let's first look at patent law, focusing on how AI has been claimed to invent new products, framed within the influential case of Thaler versus Comptroller-General of Patents, Designs and Trademarks, 2023. This was the first authoritative decision within the Supreme Court to decide that an AI machine cannot be considered as an inventor within current patent law. For context, in 2018, inventor Dr. Stephen Thaler filed 2 patent applications for new inventions, but Thaler was notified that he needed to file a statement of inventorship according to the Patents Act 1977. In response, Thaler stated that the inventor of the 2 inventions was an AI-powered autonomous machine called Dabus, and that he gained the right for the patents to be granted through owning the machine itself. 3 issues were highlighted by the Supreme Court judgment. Firstly, who counts as an inventor, and can this extend to a machine? The Supreme Court held that an inventor must be a natural person supported by Sections 7 and 13 of the Patents Act, which make it clear that inventors are human beings who devise the inventive concept. Applying this to the machine, the court confirmed that there is no indication anywhere in the legislation that a machine could qualify as such. Citing Roan Polank Rora versus Yada Research 2007, it concluded that the machine cannot be regarded as an inventor. Secondly, there was the issue of whether ownership of the machine gave Thaler patent rights. Thaler argued that he was still entitled to the patents because he owned the AI system that created them. The court rejected this, stating that Section 7 of the Act provides a complete code for those that may apply for a patent. Only an inventor or someone claiming through that inventor can do so, and Dabus is not a person, but rather a machine. Thaler also tried to rely on the doctrine of accession, comparing it to owning an animal that produces offspring. However, the Supreme Court dismissed this analogy, explaining that an invention is not tangible property that can pass by ownership of the machine that made it. The last issue that arose was whether the patent applications were properly withdrawn. Under Section 13, subsection 2 of the Patent Acts, applicants must identify the inventor and explain their entitlement. Thaler was confirmed as doing neither action, as he named no human inventor and relied only on owning Dabus. Therefore, the comptroller was entitled to treat the applications as withdrawn once the 16-month period expired under Rule 10, subsection 3 of the Patent Rules Act 2007. With these issues dealt with, Thaler's claim failed, and the Supreme Court asserted that inventorship is a human-only attribute.
So, what are your insights and takeaways from the Thaler decision? In the age of rapidly evolving AI technology and the increase of enhanced AI-created ideas, are the Supreme Court out of date with modern society?
I think that it is important to note that the court made it clear that this case does not concern whether AI-generated inventions should be patentable, but rather if an interpretation of the Patents Act allows the decision that an AI system can be recognized as an inventor. Thus, I think that the Supreme Court were narrow in the decision over Thaler, and criticism over the modern relevance of the court is unfair. However, I do think that this ruling highlights a growing tension between law and technological reality. While the decision is legally sound, as it's supported by the Patents Act within the current wording, it feels increasingly counterintuitive in a world where AI systems increasingly generate new and valuable outputs for human use. To me, the judgment reflects an outdated framework that still assumes creativity must originate from the human mind alone, which seems naive considering the capabilities of modern AI. Even patent experts and pits and masons, such as Mark Moffett and Sarah Thaler, have pointed out that the courts have avoided confronting the deeper issue of how much human involvement should be required for inventorship in the age of autonomous creation through AI. Unless UK patent law evolves, I think cases like Thaler's highlight that innovation may continue to advance faster than these legal concepts were meant to govern it.
Okay, I see what you mean, But how does the Thaler decision differ to AI created material in general in the UK?
Yeah, so that's a great question. So, copyright is governed by the Copyright Designs and Patents Act 1988, or also referred to as the CDPA. So, before the expansion of AI generated machines into everyday life, traditionally, copyright for like literacy and musical works were owned by the human author of the work because AI didn't exist then. However, many people nowadays wonder if they own the material that they have created through prompting like these generative machines, such as like ChatGPT or DeepSeek, or if the machine itself owns it. The UK is actually unusual in explicitly recognizing computer generated works under Section 9, subsection 3 of the CDPA. It states that where a literary, dramatic, musical, or artistic work is generated by a computer in circumstances such as there is no human author, the author is deemed to be the person by whom the arrangement necessary for the creation of the work are undertaken. So this provision, interestingly, assigns authorship and therefore first ownership to the human who set up or directed the system, not to the AI itself. Copyright in such works lasts 50 years from creation, and there are no moral rights attached to it. So, with this in mind, AI authorship with generated content between patents and copyright is very similar, as AI currently cannot hold or originate rights. Yet there is a small difference between the two, and that is that copyright law offers limited protection for computer generated works in the mentioned Section 9, subsection 3, by accommodating AI outputs to some degree. However, as with patent law, there is still a tension between authorship of copyrighted material and AI. Another landmark case testing the boundaries of AI and ownership is Getty Images US versus Stability AI Limited. So Getty Images, which owns one of the world's largest collection of licensed photographs, claims currently, as this is currently happening in the High Court, that Stability AI unlawfully scraped millions of its copyright and trademarked images to train its image generation tool, Stable Diffusion. The company further alleges that some of the AI's synthetic outputs reproduce substantial parts of Getty's original works and even feature distorted versions of the Getty watermark, amounting to copyright and trademark infringement. Stability AI, of course, denies liability, arguing that training occurred outside the UK and that any copying within output systems stems from user prompts rather than the system itself, with potential protection under dealing or text and data mining exceptions in UK law. The High Court and also US law. The High Court is now tasked with deciding whether using copyrighted works to train AI constitutes infringement, or whether AI outputs that resemble existing images are infringing copies. Regardless of the outcome, this case is a pivotal moment in determining how far UK copyright can stretch to accommodate non-human creativity, and whether the framework built for human authorship can survive the age of machine-generated art.
Thank you very much, B. That was very, very interesting. I think that even now that AI is in its early innings, the law really has to catch up. And we can see that, for example, as the Getty case is still ongoing, like you said. But I do look forward to seeing the outcome. And thank you, everyone, for tuning in to our first episode of the Queen Mary Legal Innovation Podcast.